Very early on, my tenure on the bench, I woke up in the middle of the night and I was plagued by a hearing that I'd held that day. A mother who I judged in a very harsh way. And I couldn't live with myself that night, thinking that I said she can't do this and she's not going to be able to do this. I'd already given up on her before I even gave her a chance to get on the right track. But fortunately, I had that moment, that night, and it really set my philosophy straight for the rest of my tenure on the bench. Since I took over the court in January of 2018, we've made quite a few changes. In my court, one of the approaches that we took was to move to 1 month permanency hearings. So every month we conduct a permanency hearing if the plan with the parent is reunification. So initially the practice of the prior court was to conduct permanency hearings every 3 months or 6 months. I realized that was not enough. 3 months waiting for a hearing when your children are in custody is an eternity for parents. By moving to monthly hearings, what I have seen is that parents feel like the process is working in their favor. I saw parents who would leave court with the plan. They would know what tasks they needed to accomplish. But I wouldn't see them for 3, 4, or 6 months, and their case had fallen off track. And so it was very hard to come back after 6 months and realize the parent misstepped, maybe they relapsed a month after we saw them. And so I lost time with these parents. Parents are encouraged when they come to court and they have the power of the court to help them get back on track. And moving to a month-to-month approach gives me the ability to make sure that this parent is progressing. If they're not, to harness the resources in the room to figure out what we can do to get them on track, and to always reiterate to them that I believe that children have a right to their parents, parents have a right to their children, and that we are really genuine in our statements to them that we want them to achieve reunification. We are called as youth court judges to step out of the traditional role of a judge and to harness the resources of the community to help families. So one of the things that I believe has been very helpful is engaging with the various shareholders, stakeholders through meetings and through training. We are working hard to become a trauma-informed court. Having an environment where mistakes are okay was important to collaboration. Another thing that I've done to promote collaboration is a group I call PAT Team. It's Partners at the Table. And we have a monthly lunch with no set agenda. Each member tells what's going on in their agency. Inevitably, at every meeting, problems are solved, even though the goal is to fellowship and to get to know each other better. So collaboration is the key. I came to the bench with no experience in child welfare, but what I did bring to the bench is a big heart, a love for people. Everybody deserves a chance, and everybody deserves my best effort. The majority of the parents already know they've made a mistake. They don't need someone to belittle them, to make them feel less of a human. They need someone that's going to speak hope into them. It's not a popular idea for a judge to use those types of words, but youth court is different. And while we have laws to follow and rules to adhere to, there's something more important, and that is the redemption of people and the restoration of families.